This week on The Communicators, a representative of the European Union discusses its approach to intellectual property and copyright issues. This program was recorded on April 27, 2009.
Our guest today on The Communicators is Devine. He is the chair of the working group between the European Union and the United States when it comes to intellectual property issues. We appreciate your time with us. And joining us in the questioning is Ananda Mazumdar with BNA. He serves as the writer for their patent, trademark, and copyright journal. Thanks for coming in.
Thank you.
When you talk about your title, how would you explain it to folks as far as what you do when it comes to intellectual properties, particularly between the EU countries and the United States?
Well, with the EU and the US is a cooperation since now a few years, an institutionalized cooperation, if you want, to review issues of common interest, try to develop concrete actions, liaise with the business, which often is the same on both sides of the Atlantic because both our economies, American and European, depend heavily on intellectual property. Actually, you could argue it's the only, or one of the most important competitive advantages of our economies.
When you look at the two economies, you talked about common interest. What are some of those?
You mean, what are the common interests?
Between our two countries. Mm-hmm.
Well, if you go through different intellectual property rights, patents, that's relating technology, trademark, copyright, and we also have geographical indications and designs, which are perhaps for the GI less cooperative approach, but we have to make sure that these rights are enforced abroad because IP rights are territorial. That means that you need, if you want, the goodwill or an international instrument to make sure that these rights are protected in countries where our businesses are exporting. And of course, as far as Europe is concerned, we're heavily depending on our exports, and our exports are a lot also IP exports. So it's very important to combine forces.
So when you're talking with our folks here about intellectual property issues, you represent various countries back in the European Union. How do you balance all those needs of those countries compared to the United States interest as well? How do you balance and negotiate those issues, so specifically when it comes to IP?
Well, as I've said, apart from the sector of geographical indications where there's a couple of tensions, and also one or two issues, one in music, because in the US there is no law allowing public performance copyrights to be paid to the right holders. That's one problem, and there was a WTO litigation actually which we won on this one, but still not implemented in the US. And there's another issue which is for trademark. The Havana Club trademark cannot be registered in the US because of Cuban-related law, which is also something which has been declared by the WTO panel at the request of the EU, something legal. But apart from these two minor examples, the broad spectrum, actually, we don't have to divide because we have the same interests. I mean, you can imagine the countries in the world which are not respecting intellectual property or not respecting it enough, and there our interests would be very, very similar.
Mr. Mazumdar.
Well, you mentioned geographical indicators as a point of disagreement, mm-hmm. and I think a lot of people are aware of the Budweiser mm-hmm. issue as an mm-hmm. ongoing disagreement, and mm-hmm. there is quite a large gap between the way Europe treats geographical indicators and the U.S.'s traditional treatment of geographical indicators. Mm-hmm. Do you see any point of compromise between the two sides on this issue?
Yeah, it's not easy to summarize, so I'll try to do my best in 2 minutes. Well, first of all, this is a debate which is not taking part into the US IP cooperation group because by definition we only talk about our cooperation issues, but also lead the EU intellectual property WTO negotiations in the Doha development round, and there you have two negotiations pertaining to geographical indications. One is called the extension, which is to extend the protection of wines and spirits to the other product, and this is where advisor would come into. And the other one is the creation of a register for wines and spirits, which has been pending since 15 years, since the TRIPS agreement of WTO has been signed in 1994. Just a word on what we call the extension, to make it very simple. Today, if you have a wine or spirit in the world, which doesn't come from the place it says it comes from, and except if in the country where it is sold it is considered generic, or if there is a prior trademark or prior use, which are three very important exceptions we don't want to change. But apart from that, this product may not be called by the name which is not representing its origin. It may not be called style, type, etc. So in other words, you cannot have, and again, unless it's generic, which is a different issue, but because in the US you have many generics, but you would have like Côte du Rhône. You cannot have a wine that's called Côte du Rhône style or Côte du Rhône kind. Now, for other products than wine and spirits, cheese, hams, but also from developing countries, coffee, rice, or even silk, like Indian silk, etc. There's few non-agricultural GIs. You may not call these products by a name which is representing the origin, but you have to prove that you are misleading the consumer. And that's a big problem because on the one hand, for wine and spirits, you have an objective protection. And the other one, you have a subjective protection, which is a nest for litigation because, of course, prove that it's misleading the consumer is extremely costly. You need to have panels, and in certain countries, litigation is extremely expensive, and GI producers can't afford that. And so what we want to do by so-called extension, and I close the answer on this one, is to extend this protection to the other one. Now, for Budweiser specifically, first of all, Budweiser is not registered as per name in GI, for instance, even in Europe. It's only the original Czech name, České Budějovice, which is protected. The second more important point, and this is, I'll finish by that on the GIs in WTO, which is different from the EU-US IP group, is that because we are not putting into questions the so-called exceptions for genericness, that is to say a name which is customary in the language, or prior trademark or prior use, that means that no one in the world will have to abandon a market in which it is, because our proposals are only forward-looking. And so in that sense, for instance, Budweiser, would be not true to say that, if the extension works, Budweiser cannot sell anymore in a country where it sells today, because it will always benefit of either the previously registered trademark if they have done so, or at least a prior use if they were selling already, or sometimes genericness, but not in the case of Budweiser probably.
I think in the last few years, the state of California has tried to acquire European-style protection for terms like Napa.
That's right.
For Napa Valley wine.
That's
Do you
right.
see support from some American sectors for the European point of view?
I think, but it's ironic because I'm here for the US corporation. I'm only speaking so far of the only non-cooperative topics, but I'll answer your question. We believe very much that the issue of GI is not an issue like, it's Europe trying to protect its name and the other ones don't have a name. That's not true. American producers, and Napa is an extremely good example, and I've spoken many times with them, is also willing to stop people free riding on the reputation which they have built throughout the years, because this is what it's about. Yeah. Now, nobody would like to be called Coca-Cola style. Nobody would accept that Fanta type product. Why should we accept Napa Valley wines? Now, Napa Valley, interestingly enough, and also because one opposes often GIs and trademarks, and it's not true. In Europe, most have both. If you have Cognac Martel, you have the GI Cognac next to the trademark Martel, and Europe is world's highest registration of trademarks. So it's not true, we don't protect trademarks as some would like to portray it. But Napa Valley, to go back to it, in Europe, has requested and obtained protection as a geographical indications. Now, they could have gone for trademark or whatever, they went for that. Which means it's also interesting for these people now, whether Napa Valley producer will have sufficient access to those who are making US trade policy shift, that's a different issue. But I think it's very much important.
If we could just briefly stick on the non-cooperative issues. You mentioned yes. Havana Club.
Yes.
Do you anticipate that the change in administration will bring any changes to the Cuba issue, which might result in change in stance on Havana Club?
Well, I don't want to get into U.S. domestic policy. I really like everybody what the President Obama has said about Cuba, that there should be a new policy. We hope that this policy will include respecting intellectual property rights which have been acquired from a Cuban government by our trademark owner, and so that Havana Club can be registered in the U.S. We can only hope. It's also a bit problematic for the US to preach, rightfully so, that other countries should apply WTO rules, etc., if itself, for two relatively minor cases, if you take the overall IP portfolio, but important, of course, for the companies involved, does not respect WTO rulings, decisions.
When it comes to intellectual property, one of the things that are talked about consistently is copyright and then counterfeiting.
Yes.
What's being done between our two countries? From what I understand, there's a long-term effort as far as coming up with some framework as far as how anti-counterfeiting efforts are being handled?
Yeah, there's two things. There is, on one hand, you have the EU-US Cooperation Working Group, which has come up with a number of results and actions. Now, one of these actions is a cooperation for the customs. And I give you two examples of what we've done very concretely to help the business. One is to have joint EU-US customs operations, which seems common sense, but not so easy to get law enforcement authorities. And a few months ago, there was an operation called Infrastructure, which in a few weeks was targeting counterfeit integrated circuits, which, as you can imagine, is a potentially very safety-related issues. Your car brakes are probably depending on this. And in a few weeks, they managed to seize 360,000 counterfeit integrated circuits between EU and US. We plan to extend that. So that's one example is the joint EU-US customs operation. Another example on the customs as well is to develop a so-called toolkit, which would allow companies who want to register their rights with the customs, so ask the customs to monitor their rights to make sure there's no counterfeit, to have a toolkit which is common for both, so that when you register with the EU and US, you can exchange, etc., and make life for everybody simple. So that's one example. Other examples of our cooperation include exchanging information through our networks of intellectual property attachés throughout the world, compare notes, compare information, possibly do joint démarches with third countries if we have a problem in common, which would often be the case. That kind of a practical thing. And then, I finish by that, but it's another wider chapter, is this new treaty. And I'm not sure when you mention anti-counterfeiting, whether you're referring to the anti-counterfeiting action of the bilateral EU-US group, or then there is this new treaty launched, those negotiations have been launched 1 year ago, called ACTA, Anti-Counterfeiting Trade Agreement. The substance of it has been released, the substance of what has been agreed so far, because it's not finished, has been released by both USTR and the EU Commission and all ACTA parties being EU, US, Japan, etc., on the website. So a lot of it is explained, and there is also a customs border chapter, etc. But I mean, I will not summarize here 6 pages.
There have been some criticisms that the ACTA negotiations have been subject to too much secrecy. Mm-hmm. What do you say to the suggestion that the talks should be more open, and that there are concerns that ACTA might result in curtailing free speech rights in the internet by narrowing the fair use doctrine or interfering with whistleblowing or government watchdog activities?
Okay, these are two different questions. First, on the principle of secrecy. Well, I know that there is no international trade negotiations happening in public. I mean, there's none of bilateral agreements is happening in public. The WTO negotiations in DDA does not happen in public. So why this one? Well, secondly, and more importantly, we do not own what the other governments are saying. I mean, it's their property. It's their negotiating position. So no one can say what the others are saying. But what is important, and I want certainly to conclude and insist on that, is that we do feel that, of course, public should be informed, because otherwise you end up with disinformation, and I will come to your second question. And this is why we have organized 2 widely followed so-called stakeholders meeting, plus on the basis of release of a very comprehensive document of what ACTA has been discussing so far, because it's not finished yet. It's been widely followed. The one I did in Europe, there were, I think, 170 businesses and consumer groups, etc., registered. So it's as democratic as can be and as transparent as can be. Now, as you can imagine, the negotiating parties don't go to ACTA out of the blue. They come with their own background of legislation. In Europe, for instance, we have very strong legislation regarding